72 hours. That's how long Donald Trump has before a federal arrest order stops being theoretical. Not a fine, not a warning, not another strongly worded filing that gets absorbed into the news cycle by afternoon. An arrest order, signed, dated, sitting in a federal docket right now, case number 124/or-RDMT, waiting for a clock to run out. Here's what happened, here's what it means, and here's why the next 3 days will determine whether the American legal system has a ceiling or whether it doesn't. Stay with me through all of it. Part 1. The number that changes everything. 47. That's the number of pages in Judge Diane M. Torres's contempt order filed Tuesday at 3:18 p.m. Eastern. Most contempt orders run 8 to 12 pages. Standard boilerplate, procedural language. This one is 47 pages long. That length is not an accident. Judges don't write 47 pages because they're angry. They write 47 pages because they are building something that cannot be appealed away. That's the first thing you need to understand. The second thing, this order doesn't just find contempt. It re-architects every remaining condition of Trump's pretrial release. From the ground up, page 31, section 4, all prior conditions of release are hereby vacated and replaced in their entirety by the conditions set forth herein. Every agreement negotiated over 3 months, every carve-out his legal team fought for, every accommodation the court made, gone. Replaced by terms the defendant had no hand in writing. That is not a judge losing patience. That is a judge closing doors. Part 2. Rewind. How a federal courtroom gets to this moment. Rewind, February 19th. Pretrial conditions hearing, Southern District Courtroom, Room 14. Judge Torres lays out the framework. The core terms are clear. No public statements referencing trial witnesses by name or by implication. Financial disclosure requirements filed every 7 days with the court's compliance officer, and geographic restrictions requiring advanced judicial approval for any travel beyond a 50-mile radius. Trump's lead attorney, Harrison Weld, 31 years of federal practice, former Deputy Solicitor General, signs the acknowledgement. Page 3 of the pretrial conditions order, filed February 19th at 4:52 p.m. Defendant and counsel both sign. That signature is binding. It is not aspirational. It is not a suggestion. It is a contract with a federal court. Here's what matters. Weld is not an amateur who missed the fine print. He wrote the fine print on cases like this for 3 decades. When he signed, he understood exactly what he was signing, which makes what came next either a catastrophic failure of client management or a deliberate calculation that the rules wouldn't actually apply. Either way, the record tells us what happened. Part 3. The escalation ladder. March 4th, 11:22 a.m. Trump posts to Truth Social. The post describes a prosecution witness, not by name, but by role, by location, by a description specific enough that legal journalists identify the individual within 40 minutes. Prosecutors flag it within 2 hours. Judge Torres issues a written admonishment the same afternoon. Not a finding, not a sanction, a warning, documented, filed, timestamped. Strike 1. March 22nd. Rally in Reno, Nevada. Trump refers to the woman they've got testifying and describes her as someone who will say anything they pay her to say. 2 witnesses in the case are women. The prosecution's motion filed the following morning, page 7, argues that the statement constitutes an implicit reference to witness B as identified in the government's exhibit list. The judge schedules a compliance review. Her written order from that review uses a phrase worth memorizing. The defendant is on notice that this court's patience is not unlimited. That sentence will matter later. Strike 2. April 8th through May 3rd. This is the stretch nobody has fully reported. It's not a single incident. It's a pattern of financial disclosure failures so consistent, it reads less like administrative error and more like a policy. Required weekly reports. 11. Reports actually filed. 6. Missing weeks. April 8th, April 15th, April 29th, May 6th, and May 13th. Page 12 of Tuesday's contempt order lays this out in a table. Column 1, required filing date. Column 2, actual filing date or the word missing in all caps. 5 rows with that word in column 2. Not 1 miss, not 2, 5. The court's compliance officer flagged each one. Each flag generated a written notice to defense counsel. Each notice was acknowledged, and then the next report was late again. That's not negligence, that's a posture. Part 4. The wire transfer. May 29th, 6:41 a.m. A wire transfer clears. $1.85 million. Originating account. Trump Organization subsidiary registered in Delaware. Entity name, Meridian Strategic Holdings LLC. Destination, a consulting firm in Scottsdale, Arizona, operating under the name Cornerstone Advisory Partners. Under the pretrial conditions signed February 19th, page 3, paragraph 6, any financial transaction exceeding $50,000 involving Trump Organization entities must be disclosed to the court's compliance officer within 48 hours. The transfer happened May 29th. The compliance office discovered it June 11th. 13 days, not 48 hours. And here's the detail buried in page 19 of the contempt order that nobody in the mainstream coverage caught. Cornerstone Advisory Partners was incorporated in Arizona on February 23rd, 4 days after the pretrial conditions were signed. The filing lists a registered agent. That registered agent's name appears elsewhere in the case record, specifically in a list of individuals prosecutors described in their April motion as having potential evidentiary relevance to the financial counts in the indictment. Not a witness, not formally, but not a stranger to this case either. The contempt order doesn't call this a payoff. It doesn't use that word. What it says on page 19, line 8, the timing and structure of this transaction, combined with the failure to disclose, raises compliance concerns this court cannot disregard. Read that again. A federal judge, in a signed order, said she cannot disregard the structure of a $1.85 million wire transfer to a company that didn't exist before his trial conditions were set. That is not a throwaway line. Part 5. The trigger. Monday, 7:14 p.m. Eastern. Trump sits down for a recorded interview with a podcast that streams to approximately 4.3 million subscribers. The interview runs 38 minutes. For the first 31 minutes, it covers campaign topics, polling, immigration, the economy. Then, at minute 32, the host asks about the trial. What follows is 6 minutes and 43 seconds that prosecutors will describe in their emergency motion, filed at 10:51 p.m. that same night, as the most direct and unambiguous violation of this court's witness communication order since pretrial conditions were established. Trump names 3 witnesses, by first name and last name. He describes one as completely compromised by the government. He says another has been promised something, I don't know what, but you'll find out. He calls the third a person who will say exactly what they're told to say because they have no choice. That interview aired live. By 9 p.m., the clip was across every major platform. By 10:51 p.m., prosecutors had filed 23 pages of emergency motions with timestamps, transcript excerpts, and 3 case citations, all documenting that this moment, this specific combination of naming, characterizing, and implying improper inducement, crossed the line the court had drawn in writing, on paper, signed by his own attorney. At 11:58 p.m., Judge Torres issued a 1-paragraph order scheduling a hearing for 9 a.m. the following morning. Less than 5 hours from interview to emergency court order. That is the speed of a judge who has been watching a clock for months and just saw it reach 0. Part 6. The hearing, 9 a.m. to 11:34 a.m. The courtroom record from Tuesday's hearing is 94 pages long. Here is what matters. Weld argued First Amendment protection. He cited Gentile v. State Bar, 1991 Supreme Court precedent limiting attorney speech about pending cases, and attempted to extend it to defendants. Judge Torres interrupted on page 17 of the transcript, line 4. Her response, "Counsel, your client is not an attorney. Gentile governs officers of the court. The defendant signed a pretrial conditions agreement. That agreement governs the defendant. Motion denied." Weld then argued selective enforcement, that other defendants in federal cases had made public statements about witnesses without contempt findings. Torres's response, page 23, lines 11 through 19. Counsel may submit a brief citing those cases. They are not before this court today. This defendant, these conditions, this record is before this court today. Motion denied. Weld tried a third approach. He argued the podcast interview was general commentary rather than witness-targeted speech. Torres ended this argument in one sentence, page 31, line 3. The defendant used their names. That was it. One sentence? At 11:34 a.m., Judge Torres read the contempt finding into the record. 4 counts, 19 documented witness communication violations, including Monday's interview, 5 missing financial disclosures, 1 undisclosed wire transfer, 2 instances of travel without prior court approval, documented in the GPS log from the monitoring bracelet his team had already agreed to in February. The order was signed at 11:47 a.m. Stayed, meaning paused, for 72 hours pending appeal. Friday, 5 p.m., that's the deadline. Part 7. What 47 pages actually builds. Here's what nobody is explaining about the length of this order, and it's the most important thing in this entire story. Federal contempt orders get appealed. Constantly. High-profile defendants have resources, and appeals courts have sometimes reversed contempt findings on procedural grounds: insufficient notice, ambiguous original conditions, disproportionate remedy. Judge Torres appears to have read every one of those reversal cases, because page by page this order closes those exits. Page 8 addresses notice, documenting every written warning with its timestamp and file number, establishing that the defendant received notice of each violation before the cumulative contempt finding. Page 14 addresses ambiguity, quoting the original pretrial conditions verbatim, and then quoting each violation against it, word for word, showing the gap. Page 22 addresses proportionality, citing 7 precedent cases where courts found similar or lesser violation patterns sufficient for contempt findings, and 3 cases where arrest orders were upheld on appeal. Page 34 addresses the First Amendment preemptively, devoting 4 pages to the distinction between protected political speech and court-ordered speech restrictions agreed to by counsel as a condition of pretrial release. She didn't write 47 pages to explain herself to the public. She wrote 47 pages to survive an appellate panel. Part 8, the other side of the record. Here is where the defense has ground to stand on, because they do, and ignoring it would make this analysis worth nothing. Not every argument Weld made Tuesday was frivolous. Not every legal scholar who's raised concerns about this case is a partisan actor. The record is complicated in ways the contempt order doesn't fully acknowledge. First, the witness communication rule. The original February 19th order prohibits public statements referencing trial witnesses by name or by implication. The phrase by implication is genuinely broad. Constitutional law scholars, including Professor Miriam Feld at Columbia, who has no public affiliation with either political party, filed an amicus letter in April noting that by implication could encompass virtually any statement about the case. She called the language constitutionally suspect at its edges. That's a real argument. Second, the financial disclosure timeline. The pretrial conditions require disclosure of transactions over $50,000 within 48 hours. Defense counsel argued in Tuesday's hearing that business day interpretation should apply, meaning weekends and federal holidays don't count. The $1.85 million transfer cleared on a Thursday. If business days apply, the disclosure window extends to the following Tuesday. The compliance office flagged it as missing on Friday, 1 business day after the transfer. Defense says that's premature flagging under any reasonable interpretation. That argument has some merit on its face. Third, the proportionality question. Arrest orders for pretrial contempt are not common. They exist, they've been upheld, but they're typically reserved for defendants who have demonstrated they cannot be managed through financial sanctions. 3 federal cases cited by the defense and acknowledged on page 38 of the contempt order itself involved similar violation patterns where courts imposed escalating fines before moving to arrest orders. Torres moved faster. Even retired federal judge Alan Pressman, writing for the Federal Sentencing Reporter in 2022, noted that arrest orders in pretrial civil contempt situations carry heightened constitutional risk when the underlying speech restrictions are themselves subject to challenge. None of this makes the contempt finding wrong. It makes the appeal viable. And a viable appeal is exactly what Weld needs to file by 5 p.m. Friday. Part 9. What this costs everyone who isn't Donald Trump. Here's the part that matters to you directly. Federal court precedents don't stay in federal courtrooms. They travel, they get cited, they become the template for how judges handle the next high-profile defendant who decides that pretrial conditions are optional. Think about what you're watching in real time. A federal judge writing a 47-page order designed to be appeal-proof. That order, if it survives, and right now the legal consensus is that its procedural foundation is solid, becomes the most cited contempt order in federal court since at least 2010. Every defense attorney in every major federal case will read it. Every prosecutor who files a pretrial conditions motion will cite it. Every judge who watches a high-profile defendant push the boundaries of court orders will reach for it when they decide how far to push back. The precedent being set in the next 72 hours is not just about one man and one trial. It's about whether pretrial conditions are enforceable for defendants with enough resources and enough platform to make compliance feel optional. That answer affects the credibility of every federal court order that comes after it. Not abstractly, concretely. In cases involving defendants who are not famous, in cases where the person on trial is your neighbor, your employer, someone whose compliance with court orders affects your life directly, courts run on the assumption that their orders mean something. Tuesday was a test of that assumption. Part 10, the 3 tracks running simultaneously. Right now, as you're reading this, 3 separate legal tracks are converging on the same point. Track 1, the appeal. Weld's team has until Friday, 5 p.m. to file. As of this writing, nothing has been filed. The appeal must address not just the original contempt finding, but the 4 counts individually, the new conditions imposed Tuesday, and the First Amendment framework Torres pre-argued in her own order. That's a complex brief to draft in 72 hours. Former appellate attorney Linda Cho, who clerked for the D.C. Circuit for 4 years, told a legal publication Wednesday, "They're not writing a brief, they're writing a constitutional argument under a deadline. Those are different things." If the appeal is filed and accepted, the stay extends until the appellate panel schedules argument. That buys weeks, possibly months. If it isn't filed by 5 p.m. Friday, the arrest order activates automatically. No additional hearing required. Track 2, Wednesday's post. After Tuesday's hearing, after the new conditions were read into the record, after Weld acknowledged them on behalf of his client, Trump posted a 3-sentence Truth Social post describing the proceeding as a show trial and the judge as a radical activist in a robe. The new conditions signed Tuesday prohibit any public statement characterizing the court, the presiding judge, or the proceedings in terms designed to influence public perception of the case. Prosecutors filed a supplemental motion Wednesday at 2:47 p.m., arguing the post violated the new conditions and requesting the stay be revoked immediately, meaning the arrest order activates before Friday's deadline. Judge Torres has not ruled on that motion yet. That ruling could come at any time. Track 3, the Thursday compliance hearing. GPS monitoring was required to begin within 12 hours of Tuesday's order. Records show the monitoring device was not installed until 29 hours after the order was signed. Defense attributes this to a dispute over the vendor and payment logistics. Prosecutors filed a separate notice documenting the delay as a compliance violation. 3 tracks, 3 unresolved problems, 1 Friday deadline. The appeal has to outrun all 3. Part 11. What Friday actually looks like. There are 4 scenarios. Scenario 1. The appeal is filed by 5 p.m. The appellate court accepts it and extends the stay. Trump's new conditions remain in place. House arrest between 10 p.m. and 6 a.m. GPS monitoring. 0 public statements about the case. While the appeal is briefed and argued, the legal fight moves to the next level. This buys time. It does not resolve the underlying contempt finding. Scenario 2. The appeal is filed, but the appellate court denies the stay extension. The arrest order activates despite the appeal. Trump is taken into federal custody pending compliance with court conditions. The appeal continues from there. This has happened before in federal contempt cases. It is not common, it is not impossible. Scenario 3. The appeal is not filed by 5 p.m., the stay expires automatically, the arrest order activates, no additional action by the judge required, marshals execute the order. Scenario 4. Judge Torres rules on the Wednesday post motion before Friday's deadline and revokes the stay early. The arrest order activates regardless of whether the appeal has been filed. Scenario 4 is the one legal analysts are watching most closely right now. Because Wednesday's post wasn't ambiguous, and Torres already showed Tuesday that she doesn't need 72 pages to make a fast decision when the record is clear. She needed 4 minutes. Where the clock stands. Tuesday, 11:47 a.m. Contempt order signed. Stay granted for 72 hours. Wednesday, 2:47 p.m. Prosecutors file supplemental motion citing new violation. Stay revocation requested. Thursday morning, GPS compliance hearing. No ruling posted as of this writing. Thursday, ongoing. No appeal filed as of 4 p.m. Eastern. Friday, 5 p.m. Arrest order activates if no successful appeal filed. Friday, unknown time. Judge Torres may rule on Wednesday's supplemental motion at any point before or after 5 p.m. Monday, July 7th. If appeal filed, appellate scheduling conference. Wednesday, July 9th. Prosecution response to appeal due. Here is the state of play. Not one unresolved problem. Not two. 4 separate legal fires burning simultaneously, all of them capable of activating a federal arrest order before the week is out, with a legal team that needs to draft a constitutionally complex brief while their client continues, publicly and on the record, to make their job harder. The 47-page order sitting in federal docket 124-00847 DMT is not waiting for anyone. The clock inside it is running right now. And the only question that matters, the one that will define how federal courts handle powerful defendants for the next generation, is whether the American legal system has just demonstrated that its orders are enforceable, or whether the last 3 months proved they aren't. We'll know by Friday. Subscribe, turn on notifications, because when that ruling posts, you're going to want it explained in real time, not in the morning when the headlines have already decided what it means. The moment it drops, we go page by page. Don't miss it.